Most inventors come to me thinking their invention failed because the idea wasn't good enough. But more often than not, the invention didn't fail, the timing did. Today, I'm talking about the number one mistake inventors make that costs them their legal rights entirely. I call it the public disclosure trap. If you've ever said, I'll share my idea now and protect it later, you are walking right into that trap. Hi, I'm Mark Trenner, and I've spent over 25 years in the IP and patent space. In my practice, it's just you and me. You work directly with me, not a junior associate, not a patent agent. Because of that, I see the raw reality of these cases every day. One of the first questions I ask every potential new client is this: is your invention still confidential? If the answer is no, my next question is, when did you first disclose this to the public? If that date was more than 1 year ago, I usually have to give them the worst news an inventor can hear. The conversation just ends here. Under US patent law, you generally cannot file for a patent if your invention was made public more than 1 year prior to filing. Period. I get it. You're excited. You want feedback. You post a coming soon teaser on social media or pitch at a local startup event without an NDA. NDAs just seem like an unnecessary step, right? Well, here's the false belief. Many inventors think if my idea is truly great, the law will protect me whenever I'm ready to pay for it. That's not true. I once spoke with an inventor who had a brilliant mechanical tool. He'd spent 2 years perfecting it and showing it to everyone he met, friends, coworkers, at trade shows. He finally had the money to file a patent application. But because he had been publicly selling and demonstrating that tool for over a year, his own success effectively barred him from ever owning the rights to that tool. He didn't lose his invention because it was a bad idea. No, it was a great idea. He lost rights to it because he didn't realize the clock was ticking the moment he started showing it around without any restrictions as to confidentiality. So, what counts as public disclosure? Well, it's a lot broader than you think. Talking to people without a signed confidentiality agreement, that's one thing. Posting the details on social media, there's another example. Pitching it to investors without a non-disclosure agreement, that could qualify. Listing it for sale on your website, almost definitely. And don't forget, we're also in a first to file system here in the US. Even if you're within your 1 year grace period, someone else could see your idea and file their own application before you get yours in. And if you have any international ambitions, many foreign countries, if not most of them, have no grace period at all. That means the moment you go public, you lose your international rights immediately. The fix is simple, but it requires discipline. You need to file before you disclose. That's it. Here's the exact steps I tell my clients. Keep it quiet until you have a filing strategy in place with your patent attorney. Next, use a provisional patent application. That's going to be the most cost-effective way to get your patent pending status and lock in your priority date before you start talking about it. Third, control the flow. If you have to share it, at least use NDAs. If you're working on something right now and you're not sure if you've already crossed that disclosure line, don't wait for the clock to run out. Reach out to me directly and let's take a look at your timeline before it's too late. Save this video as a reminder before you share your next big idea. It could save you the disappointment of knowing you just gave away your $1 million idea.